call Jacinda Ardern.
Mr Speaker, I want to begin by acknowledging that, as the Minister set out, she has indeed involved the Labour Party in the last week or so in the final stages of the drafting of this bill that is coming before the House, and I will share, as will my colleagues, some of our misgivings over the content of this bill, and we appreciated the opportunity to raise those with the Minister directly. I appreciate her giving direct responses to some of those misgivings, but unfortunately on some of them we have not yet reached common ground. I would say, though, that absolutely, in principle, we see the need for a piece of legislation like this. We continue to question, though, why it is that we are debating this bill in such a rushed way when it was clear for some many months now that this was going to be an issue that needed to be addressed. And so that is a legitimate issue that we have raised, obviously, in question time today. Mr Speaker, before we begin this debate, we need to be absolutely clear. There are two issues at play in debating the context of this bill. There is the debate around who is being deported and why. And we will continue via the good work of Kelvin Davis and of Andrew Little in continuing to question the legitimacy of the policy that has been adopted by our Australian counterparts. Because, of course, offenders from overseas have been deported back to New Zealand where they are legitimate citizens for years now. Of course they have, but the operative word there is citizens. What we have seen at play in recent times is a real muddying of the waters over when one determines someone to be a citizen and not. And we have individuals now who, for all intents and purposes, are not New Zealanders in their minds. They identify as Australians. Their families are Australians. They have grown up in Australia, in some cases born in Australia, and they are being deported to this country. We will continue to battle on that point on behalf of those who are resident here in New Zealand and for whom it does not serve well for these individuals to be deported back here, but also on the principle of human rights that these individuals are encountering themselves. And that is a point that needs to continue to be raised by all sides of this House at the highest level. Now, Mr Speaker, I have to say this is not an issue internationally that is new. There have been examples of this happening in the past. Tonga, Samoa, they know policies like this. They have a growing population of people from Los Angeles, Salt Lake City, San Francisco and Dallas. These are individuals who grew up in the United States, who have no recollection of life in Tonga, who identify as Americans, who have no family in Tonga, but have found themselves deported to that country and have found a difficult path of reintegration, let alone rehabilitation. And Mr Speaker, because we know this is a story, a policy that has been adopted by another country in the past, we can learn the lessons of a country like Tonga who have tried to then deal with the fallout of such a policy. First, the lesson should be battle the policy, and we will continue to make that point. The second lesson then is, in lieu of being able to successfully do that, how do you ensure that your country is prepared for those who are being deported back here? And there will be a range of categories. Those who sit in the minor offences category and those who do legitimately require, for the safety of the community, to be monitored within that community. But nothing in this bill speaks to the issue of proper reintegration and rehabilitation. And yet we only need to look at our own experience with offenders being released from prison to know that key to someone's successful rehabilitation is their access to housing, is their access to community support, is their access to employment, is their access to full health and well-being. That is fundamental if we want someone to be reintegrated successfully into a community. Why else, for instance, does corrections have a policy of locating offenders in a prison close to their family and their community? Why else do we have release to work programs? Why else do we ensure that parole boards don't release people from prison until they have appropriate accommodation? And yet here we have a policy where we already know people are walking out of an airport with nowhere to go. And nothing that I have seen in any of the government's preparation for this bill speaks to that point. And that serves those individuals poorly, but primarily it serves New Zealanders poorly. They are the ones whose safety we should be ensuring when we're looking for answers in a piece of legislation like this. And Mr. Speaker, we know that we need to be prepared. The Minister raised that, of course, we have had people deported to New Zealand over a number of years, but not to the scale we are seeing now and not for the range of offences that we are seeing now. In fact, we are looking at 5 times the level of deportation per month than we have in the past. And we know it's an incredible increase because those who are working in the community with these individuals have spoken of their struggle to manage that influx of individuals. And what have they received? A paltry $100,000, I believe it might be, Mr. Davis, pillars, a small amount of money in order to try and manage this huge increase in offenders. And yet what are we doing in this bill? We know that corrections, for just to be able to make sure that they do the bare bones of monitoring, just checking where people live, needed an extra $5 million. So if you're going to do a proper job of wraparound and reintegration, you're going to need a lot more than that, and yet there's nothing in the preparation of this legislation that speaks to that point. Mr. Speaker, I wanted to speak briefly to the timeline of this bill. We had a short exchange in the House before this bill came before Parliament around when the Minister first instructed Parliamentary Council Office. Of course, there would have been a bit of back and forth with officials before that point, but we know drafting began in October. Mr. Speaker, my question is, why were we able to identify overseas offenders returning to New Zealand and going unmonitored as an issue in April of 2014, and yet we did not begin this piece of work until October, or at a stretch, February? 2014, Mr. Speaker, at the beginning of 2014, that's when we debated the Parole Extended Supervision Orders Amendment Bill. I want to read an excerpt from the definition of that bill. Section 107C sets out the meaning of eligible offender for this bill, and it states, in this part, an eligible offender means an offender who is B, a person who has arrived in New Zealand within 6 months of ceasing to be subject to any sentence, supervision conditions, or other imposed on the person for a relevant offence by an overseas court. By an overseas court. We knew that we needed to apply a regime for the serious end of offenders coming in from overseas in April 2014. And yet, Mr. Speaker, we did not use that opportunity where we identified that gap in our legislation to put through a broader piece of a broader monitoring regime. And Mr. Speaker, yes, we did not have an agreement with Australia around information sharing at that point. That did not stop us from doing the preparatory work. And Mr. Speaker, we all know what issues there are when you put through a last-minute piece of legislation. This side of the House wants to ensure we have a monitoring regime. That's why we've said we'll support the bill. But we also proposed, via David Parker and Andrew Little, we also proposed that we have a dual bill process, that we put a sunset bill clause into this rushed piece of legislation for a year. That in this House, while we pass this bill today, we also conduct a first reading of a duplicate bill. That bill could then go through a full select committee process, a full second reading process, and a full final stage, all in time to replace the rushed, shortcut version in a year's time with a bill that's had full consideration. We believe that would be a much better, more robust process to undertake rather than waiting 2 years and simply having a select committee review that piece of legislation. Mr. Speaker, we stand by that suggestion. We think it was a constructive one to make. Any bill where you're putting in place the potential to curtail civil liberties should, at the very least, have a decent process through select committee. The public should be able to have their say. The legal fraternity should be able to have their say. That is how we make good law in this House, not by trial, which is essentially what this piece of legislation is about to go through. Mr. Speaker, I will use my second reading contribution to talk about some of the areas where we have concerns that we're leaving gaps open, where we're relying on corrections to highlight, in some cases, offenders who need monitoring regimes, and we know it's a press department, but I will leave that to my second contribution.